This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which we are live streaming in order to maintain our open court policy. We will conduct the hearing in the same manner as if we were all in the courtroom together. The only difference is we have increased the time for argument, realizing that we will be arguing 4 cases at the same time, all which arise out of a similar set of facts. The appellant will have 30 minutes and the appellees will have 30 minutes for their arguments. And of course, the appellant has reserved some time for rebuttal. Unless there are any announcements, I will ask Mr. Hibner to call the cases.
Turnbull Preservation Group, LLC et al. Versus Dickson County, Tennessee et al. Jeff Lunn et al. Versus Dickson County, Tennessee et al. Wayne Gray et al. Versus Dickson County, Tennessee et al. And Wayne Gray et al. Versus Dickson County, Tennessee et al.
Thank you, Mr. Hibner, and the appellant has the floor.
Judge Clement, thank you. May it please the court, I am Roger Wainett from the Dickson County Bar. And as stated, we have 4 cases in this hearing. So I'm going to try to narrow the issues a bit. In the main issue in the last 2 appeals, which are case 545 and 546, are very similar, almost identical. And that is whether the intent of the Open Meetings Act is satisfied when there's a public inquiry as to a specific item of great public importance will be discussed at a regular meeting, and the county intentionally misleads regarding whether that specific item will be considered. And to maybe even put it a little simpler is, does a violation of the Open Meetings Act occur when the public is misled regarding what the county knows and plans to discuss at a regular meeting? And of course, we feel that this is the exact behavior that the sunshine laws are intended to prevent. There are 2 things different about these cases than any I've found. Number 1, did the county produce an agenda for a regular meeting and intentionally omit an item that it knew and had planned to consider at that meeting? And the second is, for 2 separate meetings, a member of the public called and asked what was on the agenda and was misled. In one instance, he specifically asked about the Titan Partners project and told it wasn't on there. So we kind of understand how we got here is in April 23rd of 2021.
Just so I'm clear, are you starting with the cases regarding the January approval by the Planning Commission and the County Commission? Is that the cases you're starting with?
Yes,
Okay.
I am. I feel that those cases being together, we can take care of 2 cases with 1 argument. But on back in April 23rd of 2020, there was a meeting on a site plan for this project. That meeting, the trial court held that meeting violated the Open Meetings Act. Now, how we got to these last 2 cases is on July 23rd, 2020, the Planning Commission held another meeting and they denied Titan site plan and final plat.
Where's that in the record?
On whether they denied the site plan, the plat.
I didn't see any minutes or summary or anything about that meeting, only conclusory statements and argument that happened. You put minutes in for every other meeting, but you didn't for this one. So how do we know what happened?
Well, I agree that should not have been included in the decision of the trial court, but he included it in his decision on the opinion on page 160, the memorandum of opinion for 5.
Point to me in the record, other than the judge's decision, that it says that the Planning Commission overturned its prior approval on July 23rd, 2020.
That,
Where are
that's
the
not in,
minutes?
that's not in the record, and so there's no minutes. That's why I believe that there was an
Well, then
error.
how can we know what happened at that meeting?
We don't. And my bringing that up is because the trial court relied on that. In the first case, it was mentioned in the very first case of 542, the trial court said that that meeting was what created the mootness issue, with what he relied on to say it was moot.
Well, where did the trial court get that?
I don't know.
Okay,
But that's not in the administrative record.
okay.
And then the trial court again relied on it in these last two cases. So that's one of the errors that we are arguing. We don't deny that it happened, but anyway, but there was the public.
Well, you have to prove it unless everybody stipulates to it. I didn't see any stipulations in the record.
I've not stipulated either, and that's why I'm concerned that it was included in the trial court's ruling.
Okay.
In these last two issues, these last two cases, adequate public notice is at issue. And the Tennessee Supreme Court has held that we must look at the totality of the circumstances to determine whether there was adequate public notice. Now, these were regular called meetings, and an agenda is not required for a regular called meeting. But the question then becomes, whenever an agenda is provided and the public calls and inquires about a specific item that's not on the agenda, and they're informed it's not going to be on the agenda, is that not fraudulent, misleading?
Okay, is that in the where in the record is that?
So
That somebody called in?
Sure. In the case 542, it is on.
We're not talking about 542, aren't we? We're talking about 545 and 546.
I apologize. Having 4 cases, it's a little 545. It's in the record where there was actually a motion to include that in the supplement in the record, and that was denied.
So it's not in the record.
Well, we feel that that is an error because you have to look at the totality of the circumstances to include that. The transcript was included in the record that was sent.
Okay. So there is a motion in there, but the motion was denied.
Motion was denied, but the motion and the transcript was also included in the record whenever it was sent up to the Court of Appeals. In 546, the transcript was included in the petition for writ. And that's the case where Mr. Grable called the county mayor's office and specifically asked, is the Titan Partners project going to be on the agenda? And he was told no.
He was told not, it wasn't going to be, or it wasn't at that time.
He was told that it wasn't on the published agenda and that it shouldn't be included at the hearing.
But the commission controls its agenda, right? So it could be added legitimately, couldn't it?
It could be added, but whenever you add something to an agenda, I think we have to go back and we have to look, was there misleading about the agenda? And that's what I think creates the difference in these cases. It's not that something was added later, there was no natural progression. They planned it. There had already been private discussions. The county attorneys appeared prepared with packets.
How do you know that it was planned? You're ascribing a kind of a nefarious intent to public officials.
Unfortunately, I am. Well, whenever you
What's
look,
the proof of that?
the proof of that is whenever you have you had prior meetings on this. The county admits that there were several meetings that were held, private meetings. Then the county with counsel,
which is permitted under the Open Meetings Act.
Yes, as long as it's limited to the issues of pending litigation.
Right.
There's 45 items in there, and I believe only 6 of the summary items refer to the site plan and the final plat. None of the other items were ever considered in litigation, such as $1 million donation for a community purpose. And
well,
other
that was in negotiations to settle a case, though. So that's a legitimate subject of a executive session meeting with your attorneys, isn't it?
I feel that it was outside the scope of that litigation. If we were to allow basically Katie bar the door and allow anything in during these private negotiations, I think that is the exact intent that the Supreme Court held in Smith County to prevent, to basically go into a private session under the ostensible purpose of discussing public business. And that clearly violates the Open Meetings Act.
Okay. Go ahead.
Whenever and we also look at what was the intent, coming back to what was the intent. On the January 14th meeting, Commissioner Comer, this is on page 92. Commissioner Comer is talking about suspending the rules, and he said, I did vote for it, but I was torn because that forecloses the public's ability to see these terms and give us input before we act on them. He said, I ultimately supported tonight's decision because, one, the public will have their opportunity in front of the county commission. That did not occur. He says, we weren't able to discuss with the public these terms, this settlement agreement, because it was in settlement under confidence under the rules of the court. And in the briefs, the
Where in the Open Meetings Act does it say you have to consult the public?
You don't have to you don't have to allow them an opportunity to be heard. But whenever you are talking about whether there was a prior violation, and there was in the first case, to cure that violation, there does have to be an opportunity to be heard. That's outlined in Nice.
Well, Nice is a very curious and specific fact situation that, frankly, you got to convince me applies here.
Well,
Nice dealt with a Board of Education retreat that published or disseminated some information about what was going to be heard while they were specifically planning on discussing something as well. And there was proof that they did that. What's the proof here?
Well, we weren't able to dig into the proof as far as having any discovery. That was denied at the trial court. So what we have to rely on are the comments in the meeting by the commissioner and the pleadings and the brief. And in the brief, the appellees say that the public was not allowed to know because these were under Rule 408. Rule 408, okay. Rule 408 just is a rule of evidence, not a rule of privilege. It keeps any statement made in offer of settlement or compromise from being admissible at trial. And it still allows those statements to be used for other purposes. I don't think Rule 408 could be used to circumvent the Open Meetings Act.
Well, the public did hear about it when I believe it was one or two of the attorneys went through each item of the settlement.
The public heard about it, but the public was also previously told just a few hours before that it wouldn't even be discussed.
Oh, and were there any of your attorneys and members of the plaintiff class at these meetings?
On the January 14th meeting, one of the plaintiffs was there. There were several of us that were there on the January 19th meeting. But I don't believe just because, a few people have knowledge of an issue, that doesn't say that the public had notice. So I think whenever we look at the rule, I'm interpreting as saying that the public had to have notice.
So you're saying once you have an agenda, you can't change it?
No, I think you can change it. You can add something, but you can't mislead someone and tell them, oh, it's not going to be on there. Once you do that, that's crossing the line. I think the intent of the Open Meetings Act is not to create a misleading notice. And that was, that's been discussed in some of the cases where misleading notice is not adequate public notice.
In the two meetings, the Planning Commission meeting and the County Commission meeting where the settlement was approved, were there published agendas or available agendas? And if so, are those agendas actually in the record?
Yes, there was. In both of them, they were in the record. And I'm sorry, I'm off screen. I'm reaching over to get it. In the very last case, about the January 19th meeting, on page 32, there's the publication where it says that an agenda may be found, and it gives the link to it. And on page 33 and 34, it provides the agenda. The Planning Commission, there is a published agenda. There is an agenda that was in the record. Whether that agenda was published or not, there's nothing in the record that states that it was or that it wasn't. I guess what I always come back to is whenever a member of the public calls and specifically asks, is this going to be discussed? And it's not, that's where the issue arises. And I think that's what differentiates these cases from some of the other cases. Because we're talking about misleading. And another thing.
What do we do with our decision in Fisher? I mean, Fisher seems to interpret the Open Meeting Act as requiring only public notice of the meeting itself and not agenda items. And it distinguishes cases like these where special meetings are involved. I mean, I don't think there's any dispute here. Both the Planning Commission meeting and the County Commission meeting were regular meetings. So
Right.
What do we do about Fisher?
Well, Fisher, the issue with Fisher is that, or how to differentiate from Fisher, is whether there was misleading notice. I agree that an agenda is not required for a regular meeting such as these two meetings. But whenever there is an agenda that's published and someone calls and specifically asks about the item and it's withheld, that they're misled and told it won't be on there. And then comments from the commission members state that we weren't able to discuss these. I'm sorry.
Again, you're assuming someone was misled. I mean, the commission, for example, the county commission controls its agenda. And if they want to add something right in the middle of the meeting to the agenda, they can do it. So if it's not on the agenda before, that doesn't necessarily mean it's misleading. And I haven't heard any proof that it was.
Okay, whenever, and I understand what you're saying. I think that whenever
I hear allegations, but I don't hear proof.
I understand. I think the proof is looking at that the county attorneys were prepared with packets whenever they came in. That's in the record that they discussed that. The very first item and action item in the Planning Commission meeting on January 14th was to add this settlement to the meeting. I understand that the commissions, and they have to be flexible, and they're a natural progression of issues can evolve during a meeting, and you need to discuss other things. But I keep coming back to the fact of someone called and asked if it would be on there. And this isn't just one or two items. This is 45 separate items that were included. And there were prior discussions about all these items in private session. And yes, there
The
can be.
45 items, you mean each of the sections of the settlement?
Correct. I'm right. That's what I'm talking about. Each of the sections. And the vast majority of those have nothing to do with the site plan or the final plat that was part of litigation.
But at least one or two of them do.
Sure. I think there's about 6 that actually do. They do. So once the discussion.
And it's an overall settlement of litigation, which brought in a whole lot of other issues that had been a concern to Dicksonians before, right? Like the road and other points which are escaping me right now.
Sure, there were some of those. The road, the expansion and extension of 2 Mile Road was known. There was one of the things that came about is no one knew about $1 million donation from Titan to be used for some other community purpose. There was a 180-foot tall, 500,000 gallon water tank being built on Hoover Road. That's in the record. That was first noticed in this meeting. And that nobody had ever disclosed that. Public utilities. There's trading land to the county. So those issues I don't think should be included. Otherwise, what every applicant that's ever turned down at a commission meeting will do. I'm sorry. I thought I heard
getting some feedback because Mr. White's microphone is still active there. So go ahead, Mr. White.
Okay. If we were allowed to do this precedent is a very dangerous slope, because any applicant that's turned down on his first item that he submits, they simply go into private session and discuss everything. There could be all kinds of public business included, and we just say that's part of the settlement.
Well, but in that circumstance, though, you would have a legitimate argument, because there's no exception for that type of discussion about a site plan or preliminary plan. I mean, absent litigation here, you're not going to be able to do that. Just go off to the side without violating open meeting. So that's not a legitimate concern. I mean, it seems to me ultimately the relief here for citizens is if they're unhappy with the manner in which the settlement was ultimately approved, they just don't vote for the county commission. And I don't know if the Regional Planning Commission in Dickson County is appointed. I'm assuming appointed by the mayor there or whatever, is, vote someone else to make those appointments so they can get someone in there that will always hold a public hearing on any settlement approval.
Well, I think the relief that the appellants want is an opportunity to be able to be heard on the issue. And that's never happened. And the reason why I think that a hearing is required in this is because there was a lot of public business that had been discussed, and then it just comes in and votes without notice. And the cure doctrine, not just in Nice, but I think in Dossett and some other cases, says that, in order to cure that meeting, you have to have an opportunity to be heard. Cure that violation, you have to have an opportunity to be heard on the issue. And that's what the public wants. They want to be heard because we're all the time finding about new things. And remember, this was just a summary of the settlement terms. We don't even know what was in it. But whenever you live on Hoover Road and all of a sudden you find out that there's a 180-foot water tower, a 500,000 gallon water tower being built just a few hundred feet from your home, and that was part of settlement negotiation, and you knew nothing about it, but you'd been calling and asking whether this issue would be heard. You had no opportunity to talk to your planning commissioner or county commissioner. That's disturbing. And it can't be said that the $1 million, I think there's an argument to be made at least that the $1 million donation is completely unrelated.
Yeah. Well, I mean, you say there's no opportunity to speak with county commissioners or planning commissioners, but my experience has been that this public is not shy about reaching out to a planning commissioner and letting them know their views on land use. I mean, that's never been a worry. It's been my experience. I mean, was that not were your clients not already doing that?
Well, they had called, but the last action that was taken by the county commission, by the county on this was in August. And at that time, there was a resolution passed. It's in the record. And that resolution on page 75 in case 546, that resolution says, and this is after the site plan and plat had been denied, by the way, that resolution says that Dickson County is opposed to the operation of the fuel terminal along Hogan Road. So for 5 months, the public thought this issue was dead. They didn't know that this issue was being discussed privately. Otherwise, I think they would have reached out. I'm out of time. I don't want to take up my rebuttal time.
All right. Thank you, Mr. Wainick. We'll hear from you later. We'll now hear from the appellees.
May it please the court, Tom White of the Nashville Bar with the law firm Tune and White. I represent the appellee Titan. Mr. Tim Potter will be making the comments for the county. I respectfully would tell the court that we've alerted the clerk that in advance I'll take the first 10 minutes and Mr. Potter will take the last 20 minutes. I'll address my comments to the issue involving the Board of Zoning Appeals. As this court knows, there are 4 writ of certiorari cases consolidated for argument here. With respect to the facts on the Board of Zoning Appeals matter, I think the facts are undisputed. My client Titan made an application for a fuel terminal to the Dickson County authorities. That went to a gentleman by the name of Dave Darnell, who's the planning director. Mr. Darnell reviewed the zoning regulations and he concluded the fuel terminal was basically a warehouse and should be allowed under the M1 zoning category. The category for this piece of property is M1. That's the heaviest industrial area in Dickson County. And it's been zoned M1 since 1995. In addition, there's a pipeline that services this piece of property. That pipeline has been in the ground since 1977. In addition, there's a subsection of zoning regulations, C1, where it also allows warehousing. But it's very clear under C1, the language says specifically it cannot be used for petroleum products. So although warehouse is recognized in C1, it is clearly not going to be applicable here because this is a facility that has petroleum products. Under the M1 categorization, this type of terminal is allowed as a matter of right. After Mr. Darnell reviewed these matters, he made that decision and it was appealed by Mr. Wainick and some of his clients to the Board of Zoning Appeals. That hearing took place on July 7th of 2020. Again, there's no dispute about what was presented at that hearing. On behalf of Titan, I presented at the hearing and put on the proof. In addition to referencing the sections that I just did, M1 is a matter of right, C1 inapplicable because it was not to carry petroleum. I put on witnesses. The first witness that I put on was a gentleman who's a well-known engineer in the community, Daryl James. Mr. James testified that he had reviewed all these matters with Mr. Darnell, and that basically he concluded it was a pretty simple distinction. Was it going to be a warehouse, fuel terminal, or a refinery? His comment was very direct and said, if it's just a line that sends crude oil into a site, it's a refinery. It gets to the site, it gets divided between gas and diesel. But if it's basically a warehouse or a terminal, gas comes out of the site, and that's it. It's very simply what I'll call a warehouse or gas. It's a gas station for gas stations. That's exactly what the facility is. The next affidavit that I used was a gentleman by the name of Patrick Hurst. Mr. Hurst has got excellent credentials. He has master's and his bachelor's, both in the same degree of engineering. His comments were very clear. He had dealt with 300 to 350 of these sorts of activities. And his comments were that the terminal here will accommodate petroleum products arriving by truck in pipeline, storage on the site, and then transported by truck to other locations for use. A petroleum terminal such as proposed does not refine or manufacture petroleum products. Further, a refinery for purposes of regulations adopted by the Environmental Protection Agency is a facility where particular types of petrochemicals are combined to produce gasoline and diesel fuel, but that the addition of other additives such as ethanol are not considered refined gasoline. Ethanol and other additives may be added to gasoline at this terminal, but neither gasoline nor diesel fuel will be produced, and therefore the facility is not a refinery. This is followed by the gentleman's credentials where he identified the 300 to 350 other terminals he had dealt with. There was another affidavit that I presented there, and in fairness, there was absolutely no evidence put on other than a legal argument by our opponents. There was a letter from a local law firm where they said they really didn't know a whole lot about what it was, but they felt that the decision by Mr. Darnell was not appropriate. That's the evidence. And so with respect to the facts, again, I don't think there's any dispute about that. And with respect to the conclusion, the Board of Zoning Appeals then voted 3-1 to affirm the position of Mr. David Darnell. The next thing that I'll comment about is that this court is certainly very familiar with what the issue is here, and that is, did the Board of Zoning Appeals properly construe this proposed terminal as a warehouse that should have been categorized as a terminal? With respect to the standard of review, this court looks at these common law writs of certiorari on a regular basis. The cases in support are Legion and Kalin versus the City of Memphis, Laidlaw versus the Metro Board of Health, and Judge Ben Cantor's article from the 1973 Memphis State Law Review are all totally on the same page, and that is the applicant here must show the decision was arbitrary, capricious, fraudulent, and the comment that's consistent in all these authority judges is that, is there any material evidence to support the decision? In this case, I think it's absolutely clear all of the authority, all of the decisions, all of the evidence are clearly in support of this decision. There was no evidence put on whatsoever that would contradict this. With that said, when this matter was considered by the trial court, Chancellor McMillan also was very cited that these type of regulations, zoning regulations, are in derogation of the common law. They're to be construed in favor of the landowner. And in this particular case, that's our client. Again, no evidence to the contrary, presume that the landowner is a favorable interpretation. And for that reason, we think it's clear that Chancellor McMillan concluded correctly in this matter. We would ask that the matter be affirmed, that his case by the Chancellor be affirmed by this court, the case dismissed. Mr. Potter is going to address the other three cases, dealing primarily with the Open Meetings Act. I'll answer any questions, and if not, I respectfully ask the court to recognize Mr. Potter for the other three cases.
All right, hearing no further questions from the panel, thank you, Mr. White. We will now hear from Mr. Potter.
Please, the court. Your Honors, I'm Tim Potter. I do represent Dickson County. My law firm does. And thank you for hearing this case today. I'm going to speak to three of the writs that are on appeal. In the lower court, they had different numbers, so it can get a little confusing. But the first case I'm going to take up in the lower court was called 202, but I think it's now 542. And that would be the writ involving the April 2020 site plan approval that is in question. The petitioners have alleged that there was a violation of the Open Meetings Act in that in the approval of that original site plan. And there's just a couple of points I want to bring to the court's attention about that. The site plan was presented by the developer to the codes department. It was originally to be heard on April 9, 2020. That was a time of great confusion and sort of discord over COVID-19. I think there was a lot of conflicting information. The meeting on April the 9th was continued by announcement and by letter of the codes director to the members of the Planning Commission to later in the month for April the 23rd. There was no other public notice given of the meeting. I concede that. However, there were 15 people who attended that meeting other than the members of the Planning Commission, including one of the petitioners in this case. There were also other matters taken up that night that were not joined in the petitioner's action. So the Planning Commission took action that night, not only to approve a site plan in this matter, but as to other matters. Now, we have argued in our response brief that the matter is moot because that matter has been addressed on 3 now subsequent occasions. It was first addressed in July when the matter came back before the Planning Commission. It was also addressed as part of the settlement approval that's before your honors that was approved on January the 14th before the Planning Commission, and then January the 19th before the County Commission. The other point I'd like to make on that issue is, as your honors can tell from the language of the settlement agreement itself, a final plat, it's mentioned in the settlement agreement in case number 546, the last writ 546, the settlement agreement itself, page 20 of the transcript, that there was a final plat that was submitted on July the 23rd before the Planning Commission. And the reason that that's important is because that one can surmise from that, the court could take judicial notice of the fact that in order for there to be a final plat, there must have also been a preliminary plat. That was taken, action was taken on the preliminary plat in June. That gave vesting rights to the developer. And no action, nobody appealed the action of the approval of the preliminary hearing, the preliminary plat. No one appealed that. No writ was filed that was not challenged by the petitioners or their counsel. So is
that the same thing as the site plan that was discussed in April of 2020, I believe it was, in the Planning Commission, and later in January of 21 in the Planning Commission and the County Commission?
No, Judge Bennett, those are separate things.
That's what I thought. And aren't we talking about the site plan, not the plat?
We are, sir. But the point I think I was trying to make is that the preliminary plat would have given vesting rights to the developer, which essentially, once the preliminary plat is filed, it makes the site grading plan, which is what that was, a site plan for grading, moot. So not only is it, we have mootness because the site plan was addressed on 3 separate occasions, the preliminary plat was approved subsequent to the site plan. So we're not conceding that there was not proper notice of that April 23rd meeting. However, the lower court did rule against us on that. But we are saying that even if that happened, it became a moot issue. Now, Mr. White is, sir?
We had some discussion with Mr. Wainick about how we know that the site plan was taken up in the July of 2020 Planning Commission meeting, since there's nothing in the record about it. You got any comment on that?
I do. I would say it's mentioned in the settlement agreement. And the settlement agreement is in case 546, and that's page 20.
Right, but that's different from. It was approved. It was approved as part of the settlement, and that's a separate argument from it was mooted out in July of 2020.
Well, it certainly makes mention in the settlement agreement that the site plan for the terminal was submitted on July the 23rd, 2020 at the Planning Commission meeting, and it's referenced that I'm reading from the settlement agreement. So, okay. But you're correct that
the settlement agreement to get to any sort of correction of this matter.
Yeah, it makes mention of the fact that it occurred, and certainly it did occur on the 23rd of July of 2020.
Well, I'm not accusing anybody of not telling the truth, but what we deal with is the record.
Yes, sir.
And if something that is important to somebody is not in the record, that's a problem.
Yes, sir. The other two writs that have been filed by petitioner of and pertain to the approval of the settlement agreement itself, Mr. White's already spoken to the appeal of the Board of Zoning Appeals matter. Those matters were the subject of Rule 408, Tennessee Rules of Evidence negotiations with the developer who had pending actions against the county that needed to be settled. And those matters were presented to the Planning Commission and to the County Commission in executive session. That's appropriate. Those are exceptions to the Open Meetings Act. There's certainly no proof in the record at all that anything nefarious, as you pointed out, Judge Bennett, occurred. Executive sessions happen routinely. That happened. Oftentimes, time is of the essence on settlement agreements. And at the regular Planning Commission meeting, which occurred in January, and I want to point that out, all of the meetings at issue on this appeal were regular meetings, with the only exception is that initial site plan meeting that was moved from April the 9th to April the 23rd. So at its regular session that the public has general notice of, in January of 2021, the Planning Commission made motion at the beginning of the meeting to amend its agenda and add the settlement agreement to the agenda. Council,
Mr. Wayne makes a big deal out of the fact that there's a lot of stuff in that settlement agreement that doesn't strictly pertain to the site plan. He thinks that's a problem. Do you?
no, sir. My response to that would be that the settlement agreement does address the site plan. But in addition to that, oftentimes terms of litigation contain other terms. It is a negotiation with the party who's filed suit against you. And that's what happened in this case.
So in other words, it's a more comprehensive settlement than just a site plan.
Yes, sir. It is. And when the motion was made to add this to the agenda, my colleague, Mr. Mills, who's also in the county attorney's office, read every item of the proposed settlement term in public. That's in the transcript, that's in the record. And there was considerable, robust discussion regarding the terms of this settlement agreement. There was a motion made to approve it. There was a second, and there was more discussion. And it was approved. And then 5 days later, it was on the county commission agenda. I want to address that just a little bit. That was in case number 546. I think that's the county commission case appealing the action that happened on January 19 of 2021.
So it was that this approval of settlement wasn't added as an agenda item to the county commission. It actually appeared on their agenda ahead of time.
No, sir. It was also added to their agenda. That meeting was 5 days later. I will point out that in Dickson County, there's typically a work session of the county commission on the first Monday of the month. Usually items that happen at the work session then get passed to the regular meeting of the county commission meeting, which is typically the third Monday of the month. Well, the work session had already passed. And so it's not unusual. It has happened many times for at the regular meeting of the county commission whose agenda has already been made out from the work session, to someone to make a motion to add something to the agenda. And as Judge Bennett pointed out, legislative bodies have that right. That was done. And I also want to point out that on January the 19th, counsel for the petitioners was present, as was a number of other of the petitioners. Now, I think what the argument that's being made by counsel for the petitioners is that his clients should somehow have been able to address the legislative body. They should have been able to speak at a public hearing. That's not true. There are certain things that allow public hearings with planning and zoning matters, as your honors know. There are a number of things like a rezoning. That's not a rezoning here. Things like maybe an annexation approval. We have public hearings for those, but there's never going to be a public hearing on a site plan approval, a preliminary plat approval, or a final plat approval for a property owner who is already zoned for that. That doesn't happen.
Is that by law, or is it just practice that those kinds of things aren't subject to public hearings? And is there anything in the record that supports your statement?
I'm not aware of anything in the record, sir, that supports that statement, but there's no law that requires a public hearing on those matters. Certainly, I think that there are certain statutes that require public hearings. I can't cite it, but I believe that there is a statute that would require a public hearing for a rezoning that could affect adjacent property owners. I think that there's public statutes that would allow public hearings on annexations, but I'm not aware of any law that requires it.
What about Mr. Wainick's repeated citation of the Nice case?
I think the Nice case is not applicable to this case for some reasons. I'm aware of the Nice case, and here's why I think it is instructive. Obviously, the school board in that case went to another state to discuss clustering. They made certain decisions or deliberated, excuse me. Then it came back, and at their regular meeting, they had some discussion, and the matter was voted on. The Court of Appeals for the Western Section in that case said that the second meeting cured any violation that might have occurred at the first meeting. So obviously that is what we're saying here. To the extent that there was any violation in April on the site plan approval, subsequent actions would have cured it. But also what Mr. Wainick is arguing, Judge, I think in response to your question, is he is pointing to the language in Nice. He calls it a cure doctrine.
Right.
And he is saying in the Nice case that, well, if there's been a previous violation of the Open Meetings Act, then the public must be given a chance to be heard. Two things about that. I'm not sure what the policies were of the Paris Special School District were that would allow public hearing. Maybe they had something in their policies that allowed it. But second, I'm arguing that the Nice case does not require, when it says be heard, I'm arguing that it does not require that they be given the opportunity to address the legislative body. They are heard. Certainly, this was a very widely known and controversial matter in Dickson County. These petitioners were heard in every way. They each had an opportunity to address their elected officials. They had already filed writs of cert. They were being heard. And I don't think that there's any doubt that the officials who voted on this approval at the Planning Commission and at the County Commission in January of 2021, there's no doubt they knew where these petitioners stood on this issue. So they were given the opportunity to address their elected officials about it. Just not an open meeting, because I'm not aware of anything that would require that. Judge McMillan, the lower court judge, and I understand your honors are reviewing this de novo. He did an exceptional job of deciphering the facts of this case. He said that, and in response to that last question your honor asked me, he said in his opinion, the general public had ample opportunity following the public meetings to contact members of the Planning Commission and County Commission to express their concerns. And that's exactly true. We are respectfully asking that you affirm his decision. This was handled appropriately by the elected officials in Dickson County. And I will add this, they did this under tremendous stress. As I said, there's no doubt that they knew that there was opposition by several members of the public to what they did, and they handled themselves appropriately. Thank you for your time. If there's no questions, that's all I have.
Hearing no questions from the panel, thank you, Mr. Potter. We'll now hear rebuttal from Mr. Wainick.
There we go. I think I've unmuted myself.
Yes, sir. I hear you.
First, I want to address the, thank you. First, I would like to address Mr. White's argument regarding the issue the Board of Zoning Appeals. And I think on the question, there's a question of law, and that's why we're here. And the law, whenever I'm talking about the interpretation and the question of law, I'm referring to the zoning regulation. And the zoning regulation in section 5, it states that a special exception is required for any facility that is refinery related. That's not been addressed. We're not arguing that this is a refinery, but whether it is refinery related. And that was ignored by the Board of Zoning Appeals as well as by the trial court. And I think that is the question.
But couldn't we say it wasn't ignored by the Board of Zoning Appeals in the sense that they took testimony on, what could potentially fit within that category, and the testimony by affidavit and witness was, well, this is really not refinery related.
They could have, but there was nothing that stated that it was not refinery related. Everything just addressed whether it was a refinery. And again, I'll certainly concede it's not a refinery. But what makes it refinery related is whenever we look at what's related is whether it's connected. Not only is there a direct physical connection with the pipeline, but that also you're receiving unfinished product that, as Mr. White said, has to be blended. You're not receiving finished products. You're finishing what the refinery started before you can sell it to the consumer. And that after that, that's when it's distributed out to the consumers, which are gas stations. And I agree that it's kind of like a gas station for gas station, except the fact that there's a little bit more process going on at this. This isn't just taking something and just storing it. We're mixing things. We're blending. That's what the testimony was.
So blending makes it refinery related. That's your argument, right?
That not only the blending, but also the fact that it is connected via a pipeline. And we are not talking about finished products here. We're talking about unfinished products that have to be blended, as you said. And Judge Bennett, I don't know if this will help, but in case number 5, or appeal number 546, on page 151 and 153, there's agreed orders relating to the site plan and the final plat. These were filed February 26th, over a month after the January meetings. And this shows that on page 153, this shows that the site plan was deemed approved by agreed order. So it remained in controversy. 202 of the first case, 542, I apologize, I called it 202, which is the trial court's number on that. The trial court said that there was a violation of the Open Meetings Act because it was moot, but it was moot. Well, it remained a controversy all the way even beyond the January meetings. And if it's a live controversy, it's certainly not moot. And that's evidenced by a final order a month after the January meetings. And since there was a violation, I go back to Nice, because this was a special meeting. The April 23rd was a special meeting that was deemed by the trial court, and I agree with that. And Nice was a special meeting. And so we're triggering the cure doctrine again. And I don't know how much time I have left in rebuttal. I don't want to go over. Let's see. So that special meeting, there was a violation. As far as having an opportunity to be heard by their commissioners, we had no one had any idea that these items, not just the site plan and the plat, were still being considered. Because again, for 5 months, the public, they thought that it was the final plat and site plan had been denied, as well as the resolution against the fuel terminal. And the first that they find out about it was when this item was added to the agenda during the meeting. And I think it's a very dangerous slope to set here, very dangerous precedent to set that any applicant to a project that may be of public controversy simply file a lawsuit, and then you can negotiate all the terms in private. And whenever the public inquires about whether or not this item is going to be considered, they're told no, not once, but twice. I think that clearly violates the intent of the Open Meetings Act.
All right. Thank you, Mr. Wainick and Mr. White and Mr. Potter for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now adjourned.
Counsel, you are free to exit the meeting.